last year, as I say, the university wrote to the minister advising that the discussions had already commenced about the handback of the bushland above the parcels identified for rezoning in the legislation, which has always been intended for protection given its environmental values. I do have a question through you, Madam Chair, for the Honourable Member for Nelson. Which is, what consultation or what conversations has the Honourable Member had with the Aboriginal Land Council? Because I have all the information in front of me about the conversations and the consultation and the discussions that the university has had with the Aboriginal Land Council and some of the advice that's come out of that. And so I would like to know what consultation, what discussions, what advice have you had or received from the Aboriginal Land Council with regard to new Clause A?
So before I put the question that new Clause A be agreed, if any other members have got questions on the member who's moving the motion, the new clause, I urge them to put them so she's got a chance to respond to them. If not, I'll move that new Clause A be read a second time. The Honourable Member for Nelson.
Thank you, Madam Chair. It's interesting, and we haven't had a lot of time to consider this, and it's probably why the minister's misconstrued it. But that's okay. We'll try and clarify a few of those misconceptions right now, because new Clause A does not impose anything on the process that the minister, on behalf of UTAS, hasn't committed to in this place and said is already happening. What new Clause A does is to say, recognises that commitment is there, that there's an intention for land handback, that discussions and consultations are underway between the university and ALCT, and that may eventually arrive at an MOU that it relates to land handback. So it recognises that that's the intent and the statement about what's already happening. And what the new Clause A does is to say, in the meantime, while that plays out, and without putting any time frame on it or any specific expectation or outcome on it, not impacting that process at all, while it plays out, the minister would put a caveat on this section of land. And what that would mean is, in the meantime, the university can't do other things to dispose of that land that aren't about land handback. It actually is protective. So it's very interesting to have the minister suggest that I'm being culturally inappropriate in suggesting this, because I'm actually not putting any requirement on the Aboriginal Land Council of Tasmania. I'm not putting any requirement on the interactions of the university with the Aboriginal Land Council of Tasmania. I'm not imposing anything on that process that's playing out, other than that while it does, UTAS can't sell the land out or rezone the land or do something different with the land out from under the process. What I'm inviting the minister to do, and the university could be supportive of this, is to codify the fact that that is a really sensitive, important process playing out, and we wouldn't want there to be any question that UTAS would behave inappropriately in that process, or would pull the plug on it, or would do something to undermine it by doing other things with the land. That's what this new Clause A does. It isn't culturally inappropriate because it doesn't put any requirement on ALCT or impose into that space and that process at all. The caveat can be lifted once an MOU has been arrived at, or if there's a decision that actually, as a result of the interactions, there's not going to be a land handback arrived at. That's absolutely available, that any or all of the land may not end up being handed back to the Aboriginal community as a result of the negotiations that's provided for. That can happen under this. As I said, it doesn't specify anything about that process or anything about what the ultimate outcome might be. It just says there's a caveat while it's happening, and when it's concluded, the caveat's lifted. So when the minister asked me what consultation I've done, this has been done. I clearly have had this drafted today, so I haven't consulted, because actually it's about a process and protection in the bill that doesn't touch into the actions or the impact on, say, the Aboriginal Land Council of Tasmania and Tasmanian Aboriginal people. It doesn't really touch into university, except to actually say that if they're going to do something different to what they're promising, there'd be a caveat there stopping them until they finished their process of consulting and discussing and negotiating the land handback process. So it's really quite ironic, because while the Minister says that this Parliament shouldn't get in the way of land handback, what I'm trying to ensure is that university doesn't get in the way of land handback either, and actually commits to the process and stays with it. So no, I haven't consulted with the Aboriginal community, because I'm not actually putting anything on them in terms of an impact or a supposed outcome or any sort of constraint at all. I'm providing them with some additional support to ensure that the process doesn't get undermined or derailed or put aside in a way before it's concluded appropriately, as laid out here. That all reasonable efforts have been made to reach an agreement. Potentially it provides for the Land Council not wishing to acquire the relevant land or parts of the relevant land, the Land Council not wishing to have the land become Aboriginal land under the Land Act. All those eventualities can happen. So I think it's misleading. The criticisms that the Minister's making of this new Clause A are misleading. It could be because the time hasn't been available to consider it. That would be fair enough. But the thing about it is, the government didn't mention anything about Aboriginal land handbacks as part of the second reading speech. Not mentioned once in this place. Nothing was mentioned in the Minister's until the Minister's summing up, and was provided as the rationale for why there's this big void over 56 hectares that's not protected under this bill and isn't rezoned under this bill. So it's only emerged then, and we've been told to take that on faith because of the handback situation that's supposed to be playing out. So that's why at this stage I've developed this amendment to address that situation, support that situation, and ensure that fidelity of that situation, that it has the space to play out.
Actually, this new Clause A be read a second time, the Honourable Minister.
Thank you very much, and I do want to reiterate a couple of comments that I made before about the spirit by which the Honourable Member for Nelson is putting this forward, and I absolutely accept that. But I have to restate, Section 4A says that the Minister may only remove the restriction on the disposal of land if the University and the Aboriginal Land Council of Tasmania have entered into a written agreement that the relevant land is to be acquired by the Aboriginal Land Council. Not part of the land, but all of the land. And this is a predeterminated outcome. And, you know, I really do genuinely feel that is very culturally inappropriate. I do, as a minister, I feel exceptionally uncomfortable with this proposed new clause. I specifically asked the Honourable Member if she had had consultation or discussions with the Aboriginal Land Council, because that would have quite possibly changed my position, but you haven't. And I accept that, you know, this is unfolded this afternoon, but I truly believe the university has publicly, and as the member for Hobart said so genuinely, committed to what it wants to do in this space. We have it in writing to the Minister. It's been read into both Houses of Parliament. I have no reason to believe that there is not an absolute, genuine will and desire to see this happen. I really don't. But I do not feel that it is culturally appropriate for this not to be led by Aboriginal peoples, and I simply can't support the new Clause A.
Thank you, Madam Chair. Perhaps what we should consider doing now is adjourning debate until, so that during the dinner break, the Honourable Member for Nelson can have that conversation with the Aboriginal Land Council of Tasmania and come back to council.
There's a question before the chair. We need to deal with that question.
Well, I seek leave to adjourn the debate until...
There's a question before the chair, and the question is that new clause A be agreed to. That's the question.
Right, okay.
So the question is new clause A be agreed to. Those that opinion say aye.
Aye.
Against no.
No.
I think the noes have it.
Divide.
Division required, ring the bells.
I've got to make a difference. One more amendment. Oh, yeah.
All members being present, stop the bells and lock the doors, please. The question is new clause A be read a second time. Those that opinion say aye.
Aye.
Against no. No. Committee will divide. The ayes will pass to the right of the chair and the noes to the left. The Honourable Member for Montgomery. Teller for the noes. The Honourable Member for Nelson. Teller for the ayes.
Thank you. All right. You,
yes, there's only two that's not. It's
well,
Meg,
that's
so
true,
Armitage, Digan, Edmonds, yep.
No.
Forrest. Oh, Ruth.
Ruth.
They're
Are
asking
you
if you...
get this? Yep. Harris, myself, Levels, yeah.
Yeah.
I know Miss Palmer, yes.
Yeah.
She's over there.
Referee. Thomas. Yeah. 12.
We are no's.
Yep. And 2.
12.
2.
Thank you.
What did you say?
12.
That's all.
Thank you.
Order. Results of the division are ayes 2, noes 12. Therefore, the question passes in the negative. Those that opinion. Members, please resume your seats. Ready, Minister? Deputy Clerk.
Schedule 1.
Honourable Member for Nelson.
Thank you, Madam Chair. I mean to say, Schedule 1, I'm moving an amendment in my name. Schedule 1, page 14, paragraph A, after Act 1980, leave out that falls between Churchill Avenue and Sandy Bay Road, Sandy Bay. Insert instead, other than an area of land that is a proposed area within the meaning of section 7. So this amendment, members, is a fairly straightforward one. Now that we've rezoned under clause 7 of this bill certain parcels of land, what Schedule 1's doing is describing what is vested land. So therefore what is protected under the title of this bill, University of Tasmania Protection of Land Bill. And my intent is to revert as best as we can in the context of the rezoning to ensure that the rest of the land on the Sandy Bay campus is actually protected under this bill as vested land. I'm just going to grab a piece of paper I've got to take with me. To remind members that originally what the government promised in 2024 before the election to the people of Tasmania and most specifically to the voters of Sandy Bay was that the Sandy Bay campus land would be protected through having to, if it was to be disposed of, come through Parliament for approval. The original intent of the bill protected all the land on that particular folio that's outlined in the bill that extends from Sandy Bay Road right down the bottom, upwards, across Churchill Avenue and all the way up to Olinda Grove. What the bill does now, because of the compromises made at the university's demands of the government, the vested land under this bill is now confined to the small area, about 14 hectares below Churchill Ave down to Sandy Bay Road. There's the rezoned parcels and then the 56 or so hectares above Churchill Avenue that is unprotected by this bill and not yet rezoned, which we know is also under that intent to have land handback happen. Now, what I'm proposing with this is that we include that 56 hectares or so that's outside the parcels above Churchill Ave as vested land. Let's be really clear, because the government, the minister's definitely going to get up and pretend that this is somehow going to be a barrier to land handback. Let me tell you right now, the fact of it being vested land is not a barrier to that land handback process continuing and being resolved and coming hopefully to that excellent conclusion that we do hand back land, that the university does hand back land. Under vested land, all that would have to happen is that that comes through Parliament and is there in a motion, because it would be regarded as disposal of land. So it would be something that came back through Parliament, potentially to disallow. This Parliament then would be able to, yes, have a say on it, but disallowance is a very high bar. It's very hard to imagine this Parliament getting in the way of land handback for that. And it's also reasonable, I think, because what we've also heard from the Minister is that they don't intend to hand that whole area back, most likely. There's probably potentially parts of that area of 56 hectares that are going to be potentially handed back. What about the rest of it? Why doesn't that deserve protection as vested land under this bill? So again, what I'm seeking to do here is to ensure that genuinely, other than the rezoned parcels in Clause 7, described in Clause 7, other than that, from Sandy Bay Road at the bottom, all the way up through the 14 hectares below Churchill Ave, into the 56 remaining hectares above Churchill Ave, all of that becomes vested land under this bill, with the requirement that disposal of any of that land, in whatever form specified in this bill, comes through as a motion in this Parliament for oversight. It doesn't stop land handbacks, doesn't put a barrier there at all to that. What it does do is ensure that any other sorts of disposal of the 56 hectares does have the same requirements applied as vested land below Churchill Ave. And I think that's reasonable. And quite frankly, if the government gets up and says the university has no intention to dispose of other land above Churchill Avenue in that 56 hectares, and we should just take it on trust that it's all fine. Well, if they don't have any intention, then it doesn't matter to them to make it vested land under this Act. If the university has no intention to dispose of that land in any way, shape or form, great. It then is protected under this bill with the same requirements as vested land below Churchill Ave. No foul, no harm. But if the university did have an intention to try to dispose in some form of that land that in that 56 hectares that perhaps they aren't looking at handback in relation to. What this will do is make sure that it comes through this place under a motion, just like the vested land below Churchill Ave. I think this is really reasonable. Let's face it, members, this 3 categories of land was not put to us clearly at any stage. I know it came to a surprise to a lot of members when I sent information around about the fact that 56 hectares, about 57% of the campus land, wasn't protected under this bill. So I think this is a reasonable to give effect to the intent and the title of this bill. And I'd definitely like to say here on the record that in the Minister's second reading speech, when she said this, that the bill would prevent, and I quote, the university from disposing of campus land at Sandy Bay without the approval of both Houses of Parliament, there are only 2 parcels of land exempt, which we are looking to rezone. She was absolutely misleading this place in saying that. That was an incorrect statement in the Minister's second reading speech, because clearly campus land at Sandy Bay extends from Sandy Bay Road all the way up, across Churchill Ave, all the way up to Alinda Grove. That is the campus land at Sandy Bay. And there are, in fact, 3 categories of land under this bill. What I'm seeking to do is to make that statement true from the Minister, that other than the rezoned parcels, the rest is protected as vested land under this bill. If we don't do that, the Minister will have made an incorrect, misleading statement in her second reading speech, categorically, undeniably. It doesn't matter how she tries to spin it, that is clear. It prevents the university from disposing of campus land at Sandy Bay without the approval of both Houses of Parliament. There are only 2 parcels of land exempt, which we are looking to rezone. Untrue. I'm trying to make it true, though, with this amendment to Schedule 1. I hope members support it. There's actually no reason not to. If the university is genuine, if our parliamentary oversight means anything in relation to this bill, there's no reason that land shouldn't also be vested.
Question is the amendment to Schedule 1 be agreed to? The Honourable Minister.
Thank you very much, Madam Chair. The first amendment to Schedule 1 to include all of the land above Churchill Avenue as vested land is not supported for all the reasons that have been raised in the second reading speech and response, and this completely undermines the purpose of the bill. This bill provides a clear, defined and timely mechanism to unlock the value and enable it to be directed towards the investment Tasmania needs. With this bill, we have moved with certainty, securing an ongoing university presence at Sandy Bay while enabling land not required for future needs to contribute to the next chapter of higher education in this state. The STEM precinct detailed business plan by Deloitte makes the opportunity clear. New facilities would attract top researchers and educators. They would strengthen the university position as a centre of excellence in science, technology and innovation. And they would support stronger partnerships with industry, creating more opportunities for students to gain real-world experience while they learn. Importantly, a visible and accessible STEM hub would also strengthen outreach activities, increasing interest in STEM pathways for senior secondary high school students and encouraging them to continue their education here. Just seek some advice, Madam Chair.
Perhaps we could be pointed to the part of the second reading speech that deals with this area of land.
Order.
There was also a comment from the member with regard to leaving more than half of the Sandy Bay campus unprotected. And no, that is not the case. That characterisation misunderstands both the bill and the intent of the land excluded from vesting. The bushland referred to above Churchill Avenue is not unprotected. It is deliberately excluded from rezoning because it is earmarked for land return and already subject to environmental protections. This bill is designed to protect the Sandy Bay campus below Churchill Avenue and rezone 2 parcels of land to inner residential, enabling the university to realise the value of these 2 specific parcels and put towards a new STEM precinct. And also with regard to the commentary around misleading about the extent of protection, the Parliament was advised that only 2 parcels were proposed for rezoning, and that remains correct. Land not proposed for rezoning was not presented, my apologies, as development land.
Question is the amendment be agreed to? Those that opinion say, Honourable Member for Montgomery.
Thank you. I just wanted to understand, was it the government's intent when it made the election promise in 2024 that it was only the parcel below Churchill Avenue that would be protected?
No. Just seeking some advice, Madam Chair.
I know the answer, Meg.
About this time, actually. And instead of going to dinner, we went to a briefing, and that was lovely. Just Thank you very much, Madam Chair, and thank the member for Montgomery for the question. The government announced its policy to protect the Sandy Bay campus.
The question is the amendment be agreed to? Those that opinion, Honourable Member for Nelson.
About dodging the question.
Thank you, Madam Chair. Let's be really clear. The Minister just got up and implied that this was discussed in the second reading speech. It wasn't. This 56 hectares was not discussed in the second reading speech. And let me be really super clear on what I am asserting the Minister misled Parliament about in the second reading speech. I'm going to quote the quote again and point to the part that's misleading, because I'm being misrepresented here as well in the Minister's response to me. In the second reading speech, the Minister said that this bill will prevent, and I will say it now, she said this will prevent the following. Here's the quote. The university from disposing of campus land at Sandy Bay without the approval of both Houses of Parliament. There are only 2 parcels of land exempt, which we are looking to rezone. That second part of the sentence there about the 2 parcels is true. Of course, 2 parcels are there in the bill, but actually it isn't. All the rest of the campus land at Sandy Bay isn't protected from being disposed of under this bill. The 56 hectares, the 57% of campus land at Sandy Bay is not prevented under this bill from being disposed of by the university. The university can dispose of that land at any stage with no parliamentary oversight. Without the approval of both Houses of Parliament, 57% of the campus land at Sandy Bay can be disposed of without the approval of both Houses of Parliament under this bill. Just to be clear, Minister, That's where you lied to the Parliament in your second reading speech.
Order.
Madam Chair.
That is unparliamentary. I ask you to withdraw.
I withdraw.
Thank you.
I withdraw. That is where you misled this chamber in your second reading speech.
Honestly.
I am being very clear here about what was misled.
Order. If you could just sit down for a minute. I think everyone needs to, I know it's the hour that it is, everyone needs to remain calm. I mean, the members made an accusation, the minister's responded, withdrawn the unparliamentary language that you used, and I ask you just to focus on the matter in hand, the amendment before the House. You can resume.
Yes, I'm focusing on the amendment before the House, which relates to the 57% of the campus that under the bill currently is not prevented from being disposed of without the approval of both Houses of Parliament. And I'm trying to make sure with this amendment, of course, that it does have to come to Parliament as vested land like the other 14% below Churchill Avenue. Well and truly, the statement I've specified here, the part of the statement that was misleading in the second reading speech, the Minister can pretend I'm talking about another part of that statement, but I'm not. I'm talking about the bit that's misleading. The Minister cannot get away from that, quite frankly, and I think it's a shame she didn't just come and say, yes, it could be misconstrued, I'm going to clarify it now. It's a shame she didn't do that. Now, Madam Chair, wrong role. The other thing that I wanted to pick up on was that what I'm proposing here does nothing to affect the rezoning that we've already approved under Clause 7 of this bill. Clause 7 has been passed by this place. The rezoning is happening. Nothing about what's suggested with this amendment to Schedule 1 changes the rezoning. So while defaulting to talk about the wonderful, wonderful heavenly STEM facilities that are to come is one thing, it's not relevant to what I'm talking about, because the rezoning has happened. If that is to be disposed of and wonderful amounts of money realised and put towards the STEM facilities, all well and good. I really hope now that we've passed it, that does happen. What I'm proposing is not going to stop it. What I'm proposing isn't going to limit it in any way, the rezoning that's already been done. What I'm proposing is that the other 56 hectares above Churchill Avenue will be protected as vested land, such that if it is to be disposed of, it would come back through this place as a motion that's disallowable, really straightforwardly. It doesn't affect the land handback process. Doesn't affect that. That would come through too. We would all celebrate that, I think. The conclusion of that, if it does come about, wonderful. It doesn't. The government has made clear that the university may well not hand back that whole 56 hectares. In fact, they've sort of said it's probably not going to be the whole lot. There might be parts of it. We're not preempting that. So this protects the land that wouldn't be handed back, as well as vested land that would have to come through this place. It's very straightforward. There's literally no reason to object to it, other than if the university does not want the oversight of this Parliament when it looks to dispose of this land at some point in the future. That's the only reason not to do it, is so there's no accountability around the university's potential disposal of this land. There's no protection offered. It's as simple as that.
Question is the amendment be agreed to the Honourable Minister? I'll call the member from Montgomery while the Minister's getting some advice.
Well, mine's a simple question. I don't want it to be, unfortunately, diluted potentially, so I'll make sure they're listening.
Always.
Always listening.
Always.
I would just like to ask, how does the government define the Sandy Bay campus?
Oh, the Sandy Bay campus.
I'll just seek some advice.
The phrase they use. Campus land at Sandy Bay. Campus land at Sandy Bay.
Thank you very much, Madam Chair. I thank the honourable member for the question. How does the government define the Sandy Bay campus? It is defined as the land required by the university to deliver its service. In this process, it has clearly said the land above Churchill Avenue is surplus.
The question is the amendment to be agreed to. The honourable member for Montgomery, third call.
Thank you. Was that advice received that this was surplus prior to or after the 2024 election promise to protect the UTAS campus?
Just seek some advice, Madam Chair.
Minister.
Thank you very much, Madam Chair. I thank the honourable member for the question. We understand that advice was provided to government in November 2024, which is what has led to the university suggesting the amendments to this bill.
After the election.
The question is the amendment be agreed to. Honourable member for Nelson, third call.
I just want to be very clear on the record here, Madam Chair, that in the Minister, the phrasing used is disposing of campus land at Sandy Bay. And in the government's own first iteration of this bill, they defined campus land at Sandy Bay because they identified it by folio under the list. They defined it as volume 167420, folio 1. That's a small area of land on Sandy Bay Road that they were going to be making vested land, and also volume 176312, folio 1, which covers the rest of the Sandy Bay campus land, which goes from Sandy Bay Road, big swathe, up over Churchill Avenue, all the way up to Alinda Grove, and there's a list map that I provided to members in my briefing paper on this that showed what the initial bill from the government, when it was going to genuinely protect the Sandy Bay campus land, intended to do. So when the Minister states that campus land at Sandy Bay can't be sold under this, can't be disposed of under this bill without approval from both Houses of Parliament except the two rezoning parcels, it's wrong. They're only protecting 14% of it, not the other 57% of it, the 56 hectares. It's absolutely misleading. Regardless of whether the university claims it's surplus to requirement, it is campus land at Sandy Bay. It simply is.
The question is the amendment be agreed to. Those that have opinion say aye.
Aye.
Against no.
No.
I think the noes have it.
Divide.
Division required. Ring the bells. All members being present, stop the bells and lock the doors, please. The question is the amendment be agreed to. Those that opinion say aye.
Aye.
Against no. No. The committee will divide. The ayes will pass to the right of the chair and those to the left.
What's that? Yes, I did.
I appoint the honourable member for Mersey, teller for the ayes, and the honourable member for Launceston, who's not listening, teller for the noes.
Launceston.
I mean for Launceston. Let's get it out of your stupor.
For win bigger.
There you go.
Okay. Mr. Vincent. Joe. Ms. Palmer. Ms. Lovell. Where's Mr. Harris? Oh, he's over there. Mr. Gaffney. Oh, this is Mr. I'm looking for you, Mr. Gaffney, and you're right across from me. Taller.
Six Rosemary.
1, 2, 3, 4, 5. 8.
Yeah, correct weight.
Okay.
Not doing that one yet.
And you have 6.
Order. Result of the division, ayes 6, noes 8. Therefore, the motion passes in the negative. Can members all resume their seats? So the question is the schedule as read stand part of the bill. Those that opinion say aye.
Aye.
Against no.
No.
I think the ayes have it.
Schedule 2.
The question is the schedule as read stand part of the bill. Mr. Nelson, you're not moving that amendment, I assume?
Pardon?
You're not moving that amendment, just to be clear.
No, they were only relevant
Yeah.
if we had done the right thing on clause 7. So apologies, Madam
Just wanted
Chair.
to give you the
I won't be
opportunity.
moving
Yeah.
those amendments.
The question is the schedule 2 as read stand part of the bill. The honourable member for Nelson.
Thank you. I have a question on that schedule 2. I'm just going to pick up the bill again. Just because we did clarify, of course, that this isn't a map prepared by an appropriately qualified surveyor. So I just would like to know who prepared the map and why it isn't of a better quality so that we can at least even carefully see exactly where its parameters are, and why isn't it described in words as well as pictorially the way some earlier iterations of the bill, I think, attempted to do. And yeah, so who did prepare the map? Why is it so poor and not more detailed so we can actually see the specifics of its parameters? And yes, said it, I don't need to repeat it again.
Probably bodged up in DPAC.
Honourable Leader.
Thank you very much, Madam Chair. I'm advised that the map in Schedule 2 was prepared and provided by the University.
Question is Schedule 2 as stand part of the bill. Member for Nelson.
Yes, that's interesting. Prepared by the University, absolutely. Pulling some strings there, absolutely, behind the scenes for that. Then what did the government do to give itself confidence about exactly what's depicted here, given the poor quality of the map? It's very fuzzy, it's just an aerial view, doesn't even depict the whole campus. Someone's got a Sharpie pen out and drawn some lines. What did the government do to give itself confidence of exactly what's being depicted? The line at the top here is literally going through some buildings, it would look like. So I'd just like to understand what the government did to fully give itself confidence that it knew what was being depicted as rezoned here.
Just seeking some advice, Madam Chair.
What's the scale?
Actually, the fact that there isn't even a scale on here is...
Honourable Minister.
Thank you very much, Madam Chair. The government satisfied itself comparing what was provided to what had been done previously in the master plan. And of course now we see in clause 7.2, on the day in which the Act receives the royal assent, the planning minister is to cause a plan to be prepared and registered in the central plan register. A plan prepared under subsection 2 may only relate to the land that is within the proposed areas.
Member Montgomery.
Thank you. Just wondering if the government could advise if the proposed area is on the inside of the big grey line or on the outside of the big grey line, as that's a considerable amount of difference. That might be 95 million or 105 million that the university proposes to be able to get. Could you please confirm that?
Honourable Minister.
Thank you, Madam Chair. I can advise the honourable member it is inside.
The question is Schedule 2 stand part of the bill. Those that opinion say aye.
Aye.
Against no.
No.
I think the ayes have it.
Right.
Division required, ring the bells. All members being present, stop the bells and lock the doors. The question is Schedule 2 stand part of the bill. Those that opinion say aye.
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 Against no. No.
The council will divide. The ayes will pass to the right of the chair and the noes to the left. And the Honourable Member Elwick, teller for the ayes, noes, and Honourable Member for Prosser, teller for the ayes. Sitting on his seat.
Nothing.
You got me, Kerry?
Sure.
There was one more.
Thank you.
Do I need more practice?
4.
10.
Good, buddy. Order. Result of the division, ayes 10, noes 4. Therefore, the motion is resolved in the affirmative. Members, please resume their seats.
I'm back.
You want, Minister?
Yes.
Thanks, Deputy Clerk.
Schedule 3.
The question is to schedule as read stand part of the bill. Those that opinion say aye.
Aye.
Against no. I think the ayes have it.
Title: A bill for an act to ensure that certain land vested in the University of Tasmania is not disposed of without the prior approval of both Houses of Parliament, and to consequentially amend the University of Tasmania Act 1992.
The question is the title as read be the title of the bill. Those that opinion say aye.
Aye.
Against no. I think the ayes have it. The question is to report a bill without amendment. Those that opinion say aye.
Aye.
Against no. I think the ayes have it.
You didn't say resolve that. You didn't resolve that. You didn't resolve that vote. We didn't call that vote.
Didn't call the vote.
Oh, didn't I?
No.
Oh, I'm terribly sorry. Oh.
It's actually good when someone like even you makes a mistake.
That I reported the bill without amendment.
So some people said aye and some people said no, and then we didn't hear a result.
Oh, didn't you? Oh, I thought I did say it, but anyway, I think the ayes have it. Right.
I didn't hear it. No, you didn't say it. We're all hungry.
Without amendment. Without amendment.
The Honourable Chair of Committee's report say bill without amendment. Honourable Minister for Education.
I move that the bill be made a third reading. I move an order for the third reading of the bill. No. One moment, please. I just seek some advice. Mr. President, I ask the third reading of the bill be made an order of the day for tomorrow.
Question is the motion be agreed to. Those of that opinion say aye. Aye. Contrary no. I think the ayes have it. Honourable Leader.
Mr. President, it gives me great pleasure to move that the sitting be suspended until the ringing of the bells for the purpose of a much-earned dinner party.
Question is that the sitting be suspended until the ringing of the division bells. Those of that opinion say aye. Aye. Contrary no. I think the ayes have it. The sitting is suspended until the ringing of the bells.